An Accra High Court has dismissed an application for injunction filed by 2 citizens seeking to halt the implementation of a mobile traffic monitoring platform to be implemented by the Communications Ministry and Kelni GVG. The ministry had denied their claim, assuring some mechanisms have been put in place to avoid that. While earlier today in court, the presiding judge, Justice Anthony Yeboah, described the application as lacking merit. There is more in this report.
Sarah Safweje and Maximus Ametogo were seeking to freeze government's efforts to monitor real-time call traffic for purposes of calculating taxes due government. They argued in court allowing Kelni GVG to do the monitoring will amount to breach of privacy. They maintain the National Communications Authority, Communications Ministry and Kelni GVG will be connecting to all physical nodes of the mobile network operators, granting them access to monitor voice and other forms of communication. The claims of the plaintiff was challenged by the Communication Ministry, which maintained the current architecture of the platform granted access to only relevant nodes for monitoring traffic, that is, statistics relating to billing and not the actual communication. The regulator also indicated that a filter had been put in place to ensure irrelevant data was not obtained on the platform. The Ministry of Communication also informed the court that the mobile network operators had been granted access to the system to enable them determine independently what data was being monitored at any given time. Delivering his ruling, Justice Anthony Yeboah said it was obvious on the documents before him that the applicants had no personal knowledge of the common monitoring platform. He said they had additionally failed to disclose their source of information and grounds of belief that implementing the deal will amount to a breach of their rights. Justice Yeboah said the evidence provided by the Communications Ministry showed there wouldn't be a breach. He wondered why the telecommunications companies whose networks had been connected to and who are defendants in the case did not challenge the claims by the Communications Ministry. Justice Yeboah said their silence suggested the position of the ministry was unchallengeable. Justice Yeboah dismissed the application for injunction, describing it as lacking merit and peddling of evidenceless fears. Deputy Minister of Communication George Anda told reporters the decision shows government is doing the right thing.
Of course, we do recognize that this is an issue of national interest, and so we congratulate the applicants. I believe that it's just a matter of being misinformed, and clearly in the judgment you could realize that the judge was saying that there was no basis for some of the claims that was informing the application as far as he was concerned. And I think that this clearly shows that we're doing the right thing. We're listening to the concerns. I hope that this will inform everybody to believe what the Minister of Communications has been saying consistently. We are doing this for Ghana. We are doing this in the best interest of Ghana. It is not in our interest to have anybody snooping on anybody's calls because it could be us. And so there's no basis for any concern.
The substantive case remains before the court.